Our first speaker is Mary Forde, who is a graduate of Trinity College in Dublin. She qualified as a solicitor and subsequently undertook work in the area of commercial law. She then took up a master's degree in international human rights law at NUI Galway and subsequently took up a position as the legal officer at Amnesty International Mental Health Campaign in November 2008. With regard to the order of presentation, what I would like to see this morning is that both speakers could present, and perhaps we could then take questions jointly at the end of both presentations. Mary Forde, in her presentation, will give an overview of international human rights law as it relates to the Mental Health Act. Thank you.
So, can you hear me properly? Yeah. Thanks very much, Dr. Lawlor, for the kind introduction. So, before I begin, I just wanted to thank Dr. Darius Whelan and the Faculty of Law at UCC and the Mental Health Lawyers Association for inviting me to speak at your conference here today. As you know, the aim of my presentation this morning is to give an overview of the international human rights framework and how that relates to mental health. Now, I'm aware that there's probably quite a varied level of knowledge about international human rights law and mental health in the room, so I hope for those of you who have a more advanced knowledge that you'll forgive me for turning first to some of the very basic principles around international human rights law and then just basically touching on the main human rights issues that arise in the area of mental health. I'm going to focus particularly today on the right to health because I feel that we tend not to focus on that right as a human right in this context. We tend to focus on rights like liberty and autonomy and privacy, which are also obviously of the utmost importance, but they'll be touched on a lot more by the other speakers throughout the day. So just to give you a quick overview of what I'm going to be looking at. Obviously, what are human rights, where they're protected, and what the state's obligations are under international conventions. Then, more specifically, what are the human rights of persons with mental health problems, with a particular focus, as I said, on the right to health. And then I'll give you a very brief overview of Amnesty International Ireland's mental health campaign. So to begin, human rights, back to first principles as I said, are rights and freedoms that belong to all people. So they're inherent, they apply to each and every one of us simply by the fact that we're human, they're not given to us. We have them from the very start, so to speak. They're inalienable in the sense that they cannot be given up, and they can only be limited in very strict circumstances, obviously in accordance with the law. They're universal, and this is very important in the context of mental health, in the sense that human rights apply to everyone, regardless of distinction, be that disability, be it gender, be it whatever distinction you can think of. And they're also interdependent and indivisible. And that's also very important in the context of mental health. You'll see when I discuss the right to health, I'll always touch on other rights that are just that you can't separate from the right to health because they're all intrinsically linked in one way or another. Okay, sorry. So again, you're probably all well aware of where human rights are protected. At the international level, there are lots of UN conventions. There's also regional systems such as the Council of Europe. So we have, for example, the European Convention on Human Rights. And obviously also human rights are covered in national constitutions like our own Bunreacht na hÉireann and in just ordinary laws such as the European Convention on Human Rights Act. And also I've put a note in here that there's a lot in the international human rights law, there's a lot of very useful soft law guidance on what is actually meant by the rights set out in the conventions. And I've named a couple of those, such as the MI principles there at the end, just for your reference. So I think at this point it's worth actually just taking stock for a moment of the number of UN and regional conventions and treaties that Ireland is actually a party to. Here in Ireland, for very good reasons, we tend, when we think of human rights, to focus on the European Convention on Human Rights. And as I said, there are good reasons for that. Firstly, its enforcement mechanism, which is the European Court of Human Rights, is by far the most robust enforcement mechanism of any international covenant or convention. And also, as you'll be well aware, the European Convention is implemented into or incorporated into Irish law through the 2003 Act. But what I'm trying to also, I suppose, point out today is that there are a whole suite of other conventions to which Ireland is a party. And if you just look, while I take my sip, look through that list there. Many of these conventions cover a broader range of rights than the ECHR, so they don't just cover civil and political rights, but they also cover socioeconomic rights, like the right to health, for example. And it is more difficult for individuals in Ireland to invoke these rights and enforce them through the courts because they're often not actually implemented into Irish law. But at the same time, they can be very valuable and useful tools, as you'll see as I go through the presentation. Also at the bottom of the slide, I felt I had to point out two very important international human rights instruments that Ireland hasn't yet ratified. The first being the optional protocol to the International Covenant on Economic, Social and Cultural Rights, which would give individuals a right to petition the Committee on Economic, Social and Cultural Rights, so on rights like the right to health, in the same way as they can petition under the equivalent Convention for Civil and Political Rights. This hasn't been signed or ratified by Ireland yet. And even more importantly, in the context of today's conference, is the UN Convention on the Rights of Persons with Disabilities. This is one of the most recent UN conventions. Ireland was one of the first signatories to this convention when it was opened for signing, and I think March 2007, Ireland was one of the first countries to sign up. But unfortunately today, it hasn't yet ratified. Now, partly this is because we need to introduce capacity legislation to ensure that we're in compliance with Article 12 of that convention. But, you know, the capacity legislation needs to be introduced as soon as possible so that we can move on to ratify. There are now 80 countries who have ratified the convention and 50 who have ratified its optional protocol, which again gives an individual right to petition. And those countries include our nearest neighbour, the UK, which ratified both of them in June and August of last year. So just finally, still on the basic principles, just one way of sort of remembering the different facets to the state's obligations under international human rights conventions are the three words: respect, protect and fulfill. So very simply, the state must respect human rights, so in the sense that it mustn't deny or interfere with the human rights of individuals that are set out in the various covenants and conventions. It must protect those human rights by ensuring that third parties respect them, and it must fulfill them. So it must take positive steps to recognise and to ensure that those rights are made real in practice. And depending on the context and the right involved, that might involve administrative policy measures, or it might even involve legislation in certain cases. So now I'm moving on more specifically to human rights in the mental health context. And even though for most of you this slide might seem very obvious, I just wanted to put it up just to make a very brief point that people with mental health problems are entitled to enjoy and exercise all human rights, full stop. This seems very obvious, but actually if you think about it, the reason that the most recent Convention on the Rights of Persons with Disabilities had to actually be introduced was because although pre-existing human rights instruments actually had the potential to protect and promote the rights of people with disabilities, including people with mental health problems, that wasn't actually really the case in practice. In practice, people with mental health problems often have their human rights, and still do have their human rights, violated, and were left sometimes at the margins of society. So it was felt that it was needed to have a specific convention to make this very point. Not just about people who may experience mental health problems, but about people who experience any type of disability. So obviously today I'm not going to be able to cover all of the human rights that apply to all people, including people who may experience mental health problems. So this is just a list of what I hope to touch on. As I said, I'm going to concentrate probably to the largest extent on the right to the highest attainable standard of physical and mental health. I'm also going to touch very briefly on rights which are known as underlying determinants of health, such as the right to liberty, the right to privacy, such as the right to housing, education and work. Then I'm going to look at liberty, privacy and those kind of traditional civil and political rights, again very briefly because I'm conscious that other speakers throughout the day will look at those rights in more detail. And then I'm going to touch briefly on some rights that aren't new rights as such, but for the first time are enumerated in the most recent convention, the Convention on the Rights of Persons with Disabilities. And at the bottom there, I've just added in the principle of non-discrimination, because no matter what right you're talking about, the principle of non-discrimination is a core principle of human rights, has to be borne in mind, and it's a key part of every right. So turning specifically to the right to health. The right to health was included in the Universal Declaration of Human Rights in 1948, but it wasn't until the rights in that convention were turned into binding conventions in the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights that this right was fully formulated. And that was in Article 12 of ICESCR, which recognises the right of everyone to the enjoyment of the highest attainable standard of physical and mental health. I've just put physical in brackets there because I'm not trying to take away from the importance of it by any means, but just because today we're focusing on mental health. But obviously the two go hand in hand. So what exactly does this mean? Well, obviously it's not a right to be healthy, because that's not something that states can fully ensure. Being healthy depends on so many other aspects of life that it's not something that the state could be held accountable for. But what it does mean is a right to the facilities, goods, services and conditions that are conducive to the realisation of the highest attainable standard of health. And as I said earlier when I talked about how human rights are interlinked and interdependent, it's closely linked with a number of other rights and freedoms, including what I described as the underlying determinants of health and the more traditional civil and political rights. And the right to health is also underpinned again by the principle of non-discrimination and also by the principle of participation, which I'll talk about in a little bit more detail in a moment. So the right to health actually is a very practical tool, and it can be used as a lens through which to critically evaluate mental health services. So the expert committee on the convention, which I'm calling for short ICESCR, which is the International Convention on Economic, Social and Cultural Rights, they have issued a number of general comments which give you an idea of how they interpret those rights. And in one of those general comments, they have interpreted the right to health as including a requirement that mental health services are available, accessible, acceptable and of good quality. And you can see in more detail there exactly what they deem that to mean. And they've also put a huge emphasis on the need for mental health services to be made available in the community. So, for example, the first UN Special Rapporteur on the right to health, Professor Paul Hunt, put it very clearly in a number of reports when he said that states should take steps to ensure a full package of community-based mental health care and support services conducive to health, dignity and inclusion. The MI principles, which are UN soft law principles, which I referred to earlier, also recognise this right very clearly. They say that you have the right to be treated and cared for as far as possible in the community, and that you have the right to be treated in the least restrictive environment. So there are many aspects of the right to health and related soft law guidance which really highlight the need for mental health services to be based in the community. And this is obviously something that we're working towards here in Ireland with successive government policies, but as is clear from successive reports by the Independent Monitoring Group and a Vision for Change, and also the Mental Health Commission and the Inspectorate, this isn't happening at anything like the pace that it needs to happen. I've also put in here a reference to a US Supreme Court case of Olmsted versus LC, which dates from 1999. And it's probably slightly out of place here because it doesn't quite relate to the international human rights framework, but I just thought it was an interesting one because in that case, the US Supreme Court found that a failure to invest in community-based services and instead investing in institutional services to the extent that people were being inappropriately institutionalized was actually discrimination under the Americans with Disabilities Act. And I don't have time now, but it is interesting to kind of look into how an argument along those lines may in future be made depending on the development of the jurisprudence of the European Court of Human Rights, or even under the optional protocol to the Convention on the Rights of Persons with Disabilities. And then at the end there, under again the need for mental health services in the community, I've mentioned again the Convention on the Rights of Persons with Disabilities, and in particular Articles 19 and 25. Article 19 actually recognises for the first time expressly in a convention a right to community integration. And Article 25 reiterates the right to the highest attainable standard of mental health and physical health, and it also puts an emphasis on community-based services. So we need to stop and talk for a moment just about the principle of progressive realisation, because like all socioeconomic rights, the right to health is subject to this principle. And it's basically a recognition of the fact that it's not going to be possible for a state overnight to put in place a model mental health service. So instead, the obligation to provide mental health services is sort of twofold. On the one hand, there's an immediate obligation to provide a core minimum mental health services, and then there's an ongoing obligation to take steps to the maximum of available resources to realise the right to health over time, so to improve those services over time in line with best practice. And hand in hand with progressive realisation goes the need for monitoring and accountability. Obviously, if you don't have indicators and benchmarks whereby you can monitor year on year whether your mental health services are improving, then you can never judge or see whether the state is actually progressively realising the right to health. And accountability is one of those words that I personally find is bandied about quite a lot, and I sometimes wonder, are we all on the same page when we use it even? So I found this very simple and useful definition by Dr. Helen Potts, who's from the University of Essex in the UK, and she has said in the context, she's actually written a paper specifically on accountability in the context of mental health, and she's defined it as simply a process that allows the state to explain what it is doing and why, and it also provides an opportunity for people to understand why the state has acted the way it has. As part of our mental health campaign, Amnesty International commissioned Indicon International Consultants to carry out the first of 2 reports last September. And that report showed that there was a real lack of accountability for mental health services in Ireland, and that in fact there's very little or not sufficient public information out there to actually measure year on year if the state is progressively realising the right to health. We've also commissioned Indicon to carry out a second report, which should be out in the next couple of months, and that's going to look at how to improve financial accountability and performance management in mental health services, and it's actually going to provide a suite of key performance indicators to be applied to mental health services in Ireland. Tied with the principle of progressive realisation is also the principle of non-retrogression, which means very simply that you can't go back. The state can't go back on the progress that is made in making mental health services available and appropriate. So finally, under the right to health, I wanted to talk briefly about the principle of participation, which is a key human rights principle. And it's particularly important in the context of mental health. And this means participation at 2 levels, if not more, but very simply at the individual level, so that every person who has a mental health problem should always be involved in their care and treatment plan. And then at a more macro level, that individuals and their representative organisations be involved in the development, the implementation and monitoring of legislation, of policies, programmes and services relating to them. And this is something that we've become more aware of in recent years in Ireland. We have, for example, the National Service Users Executive that was established under A Vision for Change. But I think it's always worth bearing in mind that we need at all times for participation to be meaningful in order for it to be effective. So, just to move on then very quickly to talk briefly about the underlying determinants of health. And as I said earlier, these include rights like the right to housing, the right to education and the right to work. The problem for a lot of people who have mental health problems, something that we've been told a lot when we were consulting on what our campaign objective should be, was that they face real barriers to exercising and enjoying these rights. You only have to look at the statistics and the number of people with mental health problems who are unemployed to see how this is in reality. So if you can exercise and enjoy your right to housing, and particularly your rights to education and employment, they're real keys to social inclusion, and for some people they can be real keys to recovery as well. So there's a requirement on states, not only in these areas to prohibit and prevent direct discrimination, but also to make sure that they prevent indirect discrimination. And in that case, they need to make sure that there's reasonable accommodation given to all persons with mental health problems. And again, the CRPD, which is the Convention on the Rights of Persons with Disabilities, merits a special mention here because for the first time, while other conventions, and for example the European Court of Human Rights in its jurisprudence has referred to the concept of reasonable accommodation, this is the first convention that actually spells it out. It says it in the text of the convention itself, that if you fail to or deny someone reasonable accommodation, that amounts to discrimination. And it also defines it. I'm not going to call out the definition now, but I think suffice to say that could have implications for aspects of our equality legislation in the future. Now, I said as well that I would touch on some of the key civil and political rights that also tend to crop up in the context of mental health. I'm not going to go into these in detail because they're going to be covered by a number of other speakers, but just again to mention them, they include rights like the right to liberty, the right to privacy, including the right to bodily integrity and autonomy, and the right to consent to or refuse treatment, and then the freedom from inhuman or degrading treatment and torture, which is an absolute right and can never be limited in any circumstances. And as you'll be well aware, and as will be discussed throughout the day by a number of the other speakers, there's a very rich jurisprudence from the European Court of Human Rights on these rights. And at times, I think the court could probably be criticised for giving perhaps too wide a margin of appreciation to individual states in the limits that they can place on these rights. But at the same time, the European Court, I mean, there have been a lot of good decisions, and for example, European Court jurisprudence has led to the fact that we now have an automatic right to review of detention under the Mental Health Act. Again, as I've pointed out here, there's a lot of very interesting soft law guidance on the limits that should be put on these rights, or kind of the limits that should be put on the limits on these rights, if you know what I mean, and that's continually evolving. And the very interesting thing is that the European Court of Human Rights often pays heed to this other soft law guidance that isn't actually directly on its convention, but is on related conventions. But what I think is really interesting at this stage, and is something to watch in the coming months and years, is to what extent the CRPD has the potential to influence how the European Court and other bodies interpret these rights in the future. And if we just look very briefly, because I'm conscious that I'm running out of time rapidly, I've 2 minutes. Okay. I'm not even going to go through this example. I'm just going to say, if you want to take homework home, have a look out of interest at Article 5 ECHR, the right to liberty, and how it's interpreted, and even just at the wording of Article 4. And if you can look up some of the documentation issued by the Office of the High Commissioner of Human Rights, there seems to be a bit of a difference there in how they're going to be interpreted, and that kind of remains to be seen. So just before I give you a very quick, rapid overview of Amnesty's work in the area of mental health, I want to just mention once more, and I know I seem to have been saying it every second word throughout the presentation, but the Convention on the Rights of Persons with Disabilities, it doesn't create new rights. Instead, it clarifies the steps that states need to take to ensure that the rights of persons with disabilities, which includes people who may have a mental health problem, are actually in reality and in practice respected, protected and fulfilled. And it expressly enumerates certain rights that, while they're not new rights, were kind of seen as offshoots of other rights or were interpreted into other rights in the past. And it expressly sets these rights out, such as, for example, Article 12, equal recognition before the law, which relates to capacity, and Article 9, which is the right to live independently and be included in the community. And by adopting a social model of disability, this convention really marks a paradigm shift in attitudes and approaches to persons with disabilities. So really, as a country, we need to introduce our capacity legislation and move towards ratifying this convention and its optional protocol without further delay. So Amnesty International, as you know, we're a global human rights campaigning organisation. We, in our early days, worked mainly on civil and political rights issues, but since around 2003 have also been working on issues like the right to health, so around socio-economic rights. Why mental health in Ireland? I've given you 4 points there as to the reasons why mental health is a human rights issue. I could go on all day with many, many more, and I'm not even going to read those through given the time, but suffice to say that it is an issue that needs to be addressed. How do we do it? We have been trying to be true to the idea, or to the principle of participation. And so we have been trying to make sure that our campaign is led and informed by the views of persons who have direct experience of mental health problems. So we have an Experts by Experience advisory group who advised us on our campaign strategy and continue to advise us throughout the campaign. We also had a national consultation on our strategy, and about 130 people took part in questionnaires and focus groups. And we also are trying to have rights holder participation throughout the campaign. Very briefly, our overall objectives. Our overall goal is in line with the convention, basically that government implements a social approach to mental health focused on people being able to live a full life of dignity in the community. And we have three main short-term objectives. Some of you might have seen we launched a report this week on Wednesday, called The Missing Link, and it was basically calling on government departments other than just the Department of Health to take action on mental health. It's not just an issue for the Department of Health. As I said, things like education, housing and employment are huge issues for people with mental health problems. We also acknowledge that the government has committed to carrying out the next review of the Mental Health Act 2001 by November 2011. We're anxious that this be a substantive review of the Act. So not just operational, it needs to be line by line, section by section, and on the basis of international human rights law, including the most recent convention. And we'll be very interested in hearing from anyone who has views on how the Act could be improved. And finally, we're looking at the introduction of legislation to drive the provision of comprehensive and community-based services as set out in the Vision for Change. We're also doing work on mental capacity and anti-discrimination as part of those. So finally, that's just our website and also our email address. Please do get in touch if you have any interesting points you'd like to make. And I'm just going to leave you with that quote from the first core principle of the National Mental Health Policy, A Vision for Change. Thank you very much for your attention.